termination is concerned, because they were not party, then the other direction to hold a fresh process of selection, terminating the services of the affected person, is not proper. Therefore, staying the said part of the order, the parties may be relegated to before the division bench to raise all the contentions and the grounds which may be directed to be adjudicated in a time-bound manner, looking to the nature of the controversy as involved for the writ court as well as for the writ appellate court. And a council representing the writ petitioners and the state writ petitioners. Council appearing on behalf of the board. Learned Senior Counsel Gupta appearing on behalf of the board. Strenuously asked that the selection was of how many peoples? 32,000.
42,000. Plus, sometimes the learned judge is saying 36, sometimes he is saying 32. What is the basis?
Approximately 35,000.
Approximately 35,000.
32.
Approximately of 32,000 assistant teachers.
What is the basis? Then nobody knows.
Somewhere it is 36 also.
It is
One
one
single judge is 36.
He has changed that order. He has changed.
Subsequently ordered correctly.
Let me declare.
You have changed it on 6th.
You see, you will find the answer of it.
Anyway.
Appears to be more than 30,000 assistant teachers in the country. However, to call them and to hold a press interview within the time frame is not possible. In addition, it is a expensive exercise which cannot be possibly done. Full stop. On the other hand, the council appearing on behalf of the writ petitioners contains defended the orders of learned single judge and contains that once the process of selection is found at fault and the interim relief regarding termination of the services of the petitioners have been directed by the writ court, interference may not be warranted in this case. After having heard learned counsel for the parties, without expressing any opinion on the merits of the facts and the legal position as brought to our notice, we are impressed upon only one submission, that the order passed by learned single judge is without joining the petitioners,
Even in a representative capacity.
joining the petitioners as a party, or even in a representative capacity in the proceedings. Full stop. We are further impressed that once the said contention was found merit before the writ appellate court, while granting the partial interim relief, at that stage, issuance of the direction for
Holding press selection.
conducting the selection as directed by learned single judge is not justified. Full stop. Therefore, therefore, we set aside the interim order to the extent of issuance of the direction to conduct the selection afresh as directed by learned single judge. Full stop. The said order is subject to final outcome of the orders of the writ appeal, orders in the writ appeal. Full stop. We have, as we have already on the cost of repetition, it is made clear here that we have already expressed that we are not considered the merits of the contentions of any of the parties. However, we are at liberty to raise all those contentions before the appellate court, which shall be duly
On its own merits,
considered on its own merit.
including the natural justice. You can raise that it is not required. It is a huge fraud, impossible to raise all that.
All contentions. Before the writ appellate court. Mr. Considering the fact that it's a matter relating to selection and appointment of the last number of the assistant teachers, we hope and trust that such controversy ought to be decided with an earliest. Therefore, we request the High Court to expedite the writ appeal as expeditiously as possible.
And accept notice, otherwise we will be submitting.
The so and so accept notice on behalf of the writ petitioners on the top. Okay, then by consent of the parties, the case is heard.
Item 58, permission to file SLP may be granted. We are item 58.
Why you are not in the writ appeal?
We were not in the rate appeal, but our services were terminated, so we have come here.
Permission.
56, 57, same as.
Permission.
Permission case. No. It's only the permission case.
Permission.
No, not 56, not permission.
7.1 and 2, same. Permission.
Permission. 57.
You are doing a hop, step and jump.
Just
You
we'll
are
clear.
doing a
We'll
hop, step and
clear.
jump.
Yes,
Not
ma'am.
in writ appeal.
57 and 1 and 2 and 58.
7.1.
Only one. Alright. In any other case in which permission issues there?
No. Not for all.
Right. In other cases, anything want to say?
No.
Very comprehensively.
Very
Very worded.
I have patient.
Very well.
Please change the nomenclature. Doesn't sound good. Untrained teacher.
No, exactly, exactly, Milord, I wanted to do that.
Please change.
No, exactly, I wanted, Milord, just a minute. That was earlier the provision was that, Milord, that untrained can be file an application. The provision act has been amended and it has been said
2019.
by 2019, all have to be trained and all we are trained. Therefore, I wanted to say, don't say now untrained now I am. I am not untrained now. I am trained.
No, my lord.
What does your rule say?
What untrained is being used is only with respect to that selection process.
Exactly. Not for any other. Yes.
Only to contrast between those who undergone.
These were the exemptees under 23 of the NCTE Act.
Yeah.
Your lordship remembers that 5-year period.
Yes.
Initial 3, then 5. So this was that exemptee under that exemption period.
People who came on the bench.
Lordship, if I may just they withdrew the exemption.
Employees as well as board are disposed of.
Milord, effectively, what has happened in before 2009, there is no so much colleges in all over the India. There's a relaxation has been made up to 31st March 2009.
Lordship, in fact, the original vacancy did not differentiate between untrained and trained. The act required first to whoever passes the TET examination and trained, give them appointment, then whatever is left out to be given to untrained. That's as per the scheme. So the recruitment process is a same.
Mr. Kunal, I was only saying you may call them exempted teachers, you may call them
That's what the
statutorily exempted.
Untrained part of it.
Lordship, I have filed an, can I put in another word, Lord? You are fighting for teachers, employees, alike. Those are for education.
Yes.
Think one point. Now this education has come down to literacy.
Education has come down.
Literacy.
Literacy.
And therefore all this teacher, Guruji, all this, think of it. This is
But this, what Mr. Chatterjee was telling, was not.
Now, the matter is over.
Amended.
Matter is over. You
That
are
was
not
amended.
Now, may I submit one thing? This is a thing. Lord, your lordship appreciate not entire thing is not under scanner.
Similar essentially I have filed.
Recruitment entire pen is not
Still lying in
whenever it will come, this order would govern all those things.
comes.
When we will pass this.
No, let us take this. Let it come in.
Very grateful.
Permission is in this 57.1 as well as 0.2.
Just give the number.
would lordship consider granting it before passing order?
Even if you will give that grant of SLP, you can give a number even later.
But you are not going to lodge writ appeals. You are only directly coming here.
We didn't have time, in fact. We had 12th is the single judge's order, 19th is this DB order. We didn't have time to get it. We will be filing appeals.
That's. They may have to file. Better to file writ appeals separately also because.
They are doing it.
You go and file it, better. Those persons who have directly come here.
Yes,
Lordship, consider granting
Because,
it
because
before-
we had only about 3 days to file our appeal and they're from various parts of the state. We could not gather the time to get it. We'll do it at ASAP. Would like to.
Late Lordship. My Lord, the first appeal was filed with a delay of 1477 days, my Lord, which was dismissed. My Lord, yes, criminal case was registered, my Lord, because the allotment, my Lord, is the under the reserved category. No, my Lord, under.
Taken 4.
Yes, my Lord.
What happened to Dharamchand's case, criminal amendment 26292?
My Lord, Dharamchand's case is still going on. The,
You should have got this tag to Dharamchand's case and argued it with Dharamchand.
my Lord, that is only a criminal case, my Lord.
No, Dharamchand is criminal case.
Yes, my Lord.
But there the question of multiple plot is-
Multiple allotment, of course, for the first time, my Lord, came in Dharamchand's case.
For all.
My Lord, when it went to the Supreme High Court in a bail matter, my Lord, then the Honorable High Court directed the authority to conduct a survey and to see that in how many cases.
So it is not only a criminal case. You could have heard this, had this revision tagged to that case, I am saying. Notice. Taken 4 plots.
Issue notice.
Number 27.
May please.